Hello, I'd like to talk to you today about what to expect at your Social Security disability hearing. Disability hearings are much less formal than court trials. There's no jury, no opposing attorneys. The judge may not even wear a black robe. The hearing rooms, for the most part, are small rooms. There's a conference table and recording equipment. All of them now have computer equipment as well. The judge usually sits at a desk that's a little elevated, slightly above the conference table. You're going to be seated at the conference table with your attorney. Hearings average an hour or so. Sometimes they can be longer. There is a vocational expert testifying at about 60% of the hearings, and a medical expert slightly less than 20%. There'll also be a judge's assistant, and that person is going to be running the recording equipment. Each judge conducts a hearing differently. The length and content of his opening statements will vary, as will the degree to which the judge asks you questions and whether the judge asks you questions before or after you're returning. Some judges will ask your witnesses to remain in the waiting room while you're testifying. Others want them out in the lobby until it's their turn to testify. In a typical hearing, the judge is going to begin by stating who is present, and he'll note that there's an attorney representing you. He may try to put you at ease. The judge usually gives an opening statement describing how the hearing is going to be conducted, giving you a little information about the hearing, sometimes presenting the history of your claim, and stating the issues. Your attorney may give a brief opening statement if your case hinges on difficult or unusual issues. After the witnesses are sworn, you're going to usually be questioned first. The judge may ask you a lot of questions, or instead he might just rely on your attorney to ask and get your testimony. You'll find a detailed list of questions you may be asked at the hearing at this website's library under your disability hearing in the article that's called Your Testimony. After your testimony, witnesses will then be questioned, and your attorney may finish with a concise closing argument. Sometimes at the end of the hearing, the judge will give an oral decision establishing that you are disabled. If so, a short written notice will follow a few days later. That doesn't typically happen. Usually the judge will make a decision after the hearing, and you won't know until it's mailed to you. I hope you found this information helpful. If you need assistance with your Social Security disability claim, and you live in northern Georgia or the metro Atlanta area, here's my contact information.